I am going to enable screen sharing and turn it over to our attorneys from the Winter Springs, Orlando area office. This is Alan Schwartzseid and Charles Nix. You can call him Chuck if you know him well. And here we go. Take it away, gentlemen.
All right. Well, I'll go ahead and just introduce myself, and then Chuck's going to take over some of the general information, but we'll kind of bounce back and forth throughout. So, my name's Alan Schwartzside. As Jeff mentioned, I'm the managing partner of the Winter Springs office for our firm. Out of our firm, we've got 25 attorneys, four offices in Pompano, Palm Beach Gardens, Tampa, and as I mentioned, Chuck and I are in Winter Springs. Out of those 25, eight of the attorneys in the firm are board certified specialists in this area of law, including myself. What that means is that the Florida bar basically considers us experts. And I say basically just because I'm not supposed to say it, but that's what it means. We've also got a board certified attorney in construction law, pretty much start to finish anything that your community may need, whether it's day-to-day guidance, amendments, covenant enforcement, collection, or any of the topics we're going to discuss today. We're happy to help. But that does require that we actually be working with your community. Like Jeff mentioned, anything we say today is not going to be legal advice. It's just going to be our thoughts on a topic without your governing documents in front of us. And unfortunately, for a lot of these issues, especially with respect to guest restrictions and screening, unless we say it's statutory or case law, it really does require a review of your governing documents. But all that said, happy to help whenever we can. If you're happy with your attorneys, congratulations, stick with them. If you're not 100% satisfied, feel free to reach out. My email address is on the screen, so is Chuck's. They're also right here in the materials that we're going to pop open in just a moment. And Chuck, do you want me to go ahead and share the screen and go through, or you want to do that?
Yeah, that'd
Okay.
be great if you don't mind, Alan. Thanks.
All right, no problem. I will go ahead and do that. And Chuck, if you want to introduce yourself, then we can go ahead and get started in earnest.
Yeah, good morning, everyone. Thanks for joining us. My name is Chuck Nix. I am also with KBR, as Alan said, in the Winter Springs office, and we're really happy to have you today. So today is guest restrictions and screening tenants and new owners. Is it worthwhile? And those are just some backgrounds on us that we will not read.
Oh, you're not going to read the whole thing, Chuck?
Not the whole, not any of it.
I,
No.
I'm joking. So
I don't
just so
even like to
everyone's
look at my
aware,
own picture, to be honest.
after we're done today, everyone will be able to get a copy of this once you fill out your survey. So we're gonna, if we skip through anything, don't freak out. You're gonna get these slides. If you want to take notes, have at it. But anyway, I'll shut up. Chuck, it's all you, my friend.
Yeah, and we'll also answer some questions at the end as well. So we always stick around for that. So I'm happy to have you. Again, guest restrictions and screening new tenants and owners. So let's get right into it. We can just run to the next one. So just as Alan was saying, this area of our area of the law is very, very governing document heavy. So let's just run quickly again through those. Documents and the hierarchy is, which refers to court standards when they interpret and apply these documents. So you've got your declaration of condo. Everyone in 7.8 under in condo world under Chapter 718 says the deck. Most people in the HOA world in Chapter 720 of the Florida statute. So you'll hear us referring to 718 and 720. I'm sure most or all of you know that. Just I'd like to be a clear communicator. And lots of people in the HOA world will also refer to the deck as the CCRs because they're often titled Declarations of Covenants, Conditions, and Restrictions. Okay. Next, you have your Articles of Incorporation. This is the document that outlines the structure and the powers of the association itself. Down one is the bylaws. Down one in the level of hierarchy, this is your the rules for the operation of the association. Procedural side, so meetings, elections, directors, officers. And then you have your rules and regs, and these are board-made policies. They must be board-made rules, reasonable, supported by the deck or the bylaws, and cannot contradict anything in the governing documents. So those are three very important subsets to ensure that each rule and reg complies with and discuss with your attorney and CAM as necessary. So
Look, if I can
let's
just
move
jump in there,
down.
'cause I
Yep,
know a lot
jump
of
in.
people don't necessarily understand what the declaration does, you explain really well what these documents mean, but I want to be clear, the declaration, the reason it's at the top is because it's recorded necessarily before anyone actually purchases a lottery unit within your community. And so anything in Florida that is recorded first in time
Yeah.
is considered first in right. That's the law of the land and throughout the state of Florida. And so this is really when you talk about the declaration, this is your constitution for your community. So you would compare that to the Constitution of the US, of the state of Florida. It's just limited to governing your community. And that's part of why it comes first in priority in all of these documents. As you gradually go down, it's usually sometimes it's a lower vote to change these documents. The rules and regs, that's going to include a lot of your your architectural criteria, your rules, and most of these screening restrictions that are more specific. So we'll get into where they need to be authorized. But as Chuck mentioned, the specifics may only be in your rules and regs. That's okay as long as your governing documents authorize it. Like Chuck said, it needs to be authorized in your declaration or bylaws. So I just wanted to be clear. A lot of people don't understand why this hierarchy is what it is. The rules and regs are usually adopted by the board. So if that can change at any
Right.
time without the members' input, of course, that's going to be given the least amount of credence by a court. So it's this level of priority in court, but understand also in the event of a conflict, if the bylaws say you don't have a right, the declaration says you do have a right, the declaration is going to control and so on within these four documents. So I just wanted to be clear on that point too, that it's not just the hierarchy in court. What's also important is it's the hierarchy in evaluating conflicts between these documents. Because let's be realistic, your developer probably didn't care all that much
Yeah.
if they were writing these perfectly. They cared whether their counsel cared whether it was going to actually take them a lot of work to get this done, or if they could use a set of governing documents from a whole bunch of older communities. So, Chuck, sorry to
Right.
step in, but I did
No,
want to
no,
clarify those points.
that's an excellent point. And then just to even top that all off and make it even more complex with your hierarchy,
Well,
remember you have seven, eight, the statutes floating around. They're not really in a hierarchy. So in this governing document hierarchy, but still applicable depending. Okay. So let's get into the kind of the meat of this specific guest restrictions. Let's go over some definitions. We got right of approval versus a ROFR or right of first refusal. Right of approval allows the board to directly approve or disapprove a prospective buyer, tenant, or transfer based on criteria like background checks, their finances, or even interviews conducted by management or the board. A right of first refusal gives the association or its members or designees the first chance to match a bona fide third party offers price and terms before the owner can proceed with the sale or lease. Okay, so two totally different concepts, both of which are going to be must be contained within your declaration. Uh, Interestingly, generally unenforceable. I'm sorry, I'm just reading my notes here. So it must be contained in the declaration. With respect to sales, and Alan, correct me if I'm wrong, but as a standalone right to approve sales, they're generally going to be unenforceable. Is that pretty much
yeah, if it's just in a board made rule, that's what I mentioned just a moment ago, and you're
right?
100% right. If it's not in the declaration or the bylaws, and realistically, it should be in the declaration itself, it's not going to be
Right.
enforceable because it's not going to be supported by the declaration. And keep in mind, when we're talking about the right to, the legal term is alienate real property. It's really
Right.
use it the way you want, sell it, get rid of it, whatever. That's a pretty strong right. And so if it's not directly in the governing documents, meaning the declaration or the bylaws, this really wouldn't be in the articles. But if it's not in there specifically authorizing the association to have these rights of approval or right of first refusal, you don't have it. So yeah, I mean it's such an important right to be able to primarily do what you want, not necessarily, make the architectural modifications you want, but to be able to sell or lease your property, that it really needs to be in the declaration, Chuck.
Yeah, yeah, thank you. And so you want to avoid it being an unreasonable restraint on alienation. Now leases are going to be, so that's sales versus a lease. Generally, the right of approval is permitted for leases if the standards are set forth explicitly in the governing documents. Again, this is going to be a recurring theme, as you can probably see. A couple of big red flags that we'll point out right now, and we'll get into a little bit more later. Be careful of discriminatory standards. Even credit scores, which Alan or I, we're not sure yet, we'll discuss later, can be considered discriminatory. And the restrictions must also comply with your fair housing laws too. So, there's a lot to think about. So let's go to screening and background and investigation fees. So associations under both the Condominium and Homeowners Association Act can charge fees for screening or background investigations of prospective buyers or tenants, but again, only if explicitly authorized in your governing documents. Okay, the fees must be reasonable, non-discriminatory, and comply with fair housing laws. And the fees are typically required to cover costs like credit checks, criminal background checks, or interviews again. Florida law does not require refunds if the application is denied, but overcharging often leads to disputes and penalties can be incurred. So, Alan, did you have anything more to say?
Yeah, I mean there is a statutory cap. It's 150.
Right.
Keep in mind that is per person, but if it's a married couple, and I think we'll get into some of this later in the slides, but if it's a married couple, they only pay one fee. There's a lot that goes into just the charges, but you do have to have at a minimum some form of resolution that the board has adopted in writing in order to charge this. You have to have the ability to screen in order to charge it. And because keep in mind, some communities will do this just as a protective measure. They'll screen without being able to approve or deny. That's not necessarily a problem. The question is whether you have the ability and authority to charge that fee. So that's the only thing I'll add there for now, Chuck.
Yeah, thank you. Yep, that was my other point too. So let's move to security deposits, whether an association can require a security deposit. And the answer is that they can, again, under both 718 and 720, require tenants to pay a security deposit as part of rental approvals. But again, only if explicitly authorized. I almost don't need to say it now, right? These deposits protect the association. So here's the concept: against damage to common areas or property caused by, or damage to other property caused by the tenant. Now, these security deposits are separate from. They're not a landlord-tenant security deposit, which are covered under a totally different section of the Florida statutes. That's chapter 83. That's your residential's part 1, commercial evictions are part 2, and there's miscellaneous evictions in part 3, like I think storage units, things like that.
Chuck, let me just add one more point about these security
Yeah,
deposits. Do yourself a favor and make sure that it's clear when you're having people fill out a form and getting and gathering those security deposits. Make sure it's clear who that goes back to at the end of the lease. Is it the landlord? Is it the tenant? Is it nobody? If there's no damage that you're using that for, because I've seen situations where we had a landlord and a tenant and the association got a demand from both. And because there was no documentation, kind of like an escrow agreement saying, here's where the money goes when this lease term is over, the association actually had to file a lawsuit so that they didn't get sued, put the money in trust with the court, and then ask the judge to award the association the fees and costs incurred. It ended up costing more to get that money back than what was actually in that $5,000 deposit. So, bottom line, to save yourself a lot of headaches down the road, make sure that when you get that security deposit, whether it's for a rental, for construction work being done in the community, just make sure that there's something signed by the person that's making the deposit or the owner that specifically says this is who the money goes back to when this is done.
Yeah, that's a great point. I think that's pretty much applicable to any area of the law, at least in the state of Florida where we're licensed. I mean, if you're dealing with money, get it, figure out where it's going, when whatever event occurs, right? Okay,
Right.
anyways, just a general statement, but specifically under 718, I think the security deposit's capped at 1 month's rent, right, Alan?
Yes.
Yes, and 720 doesn't have a cap. My notes just say must be reasonable and should be based on actual risk, right?
Yeah, and I'll be honest, I have a feeling a judge would say if you're asking for 6 months rent as a security deposit, that's probably not going to be reasonable. So I would
Yeah,
stick to
like
that 1 month.
500 to 2,000, something like that was
Yeah, I
probably
would stick to
reasonable.
the 1 month, maybe two at
Yeah,
most. And I think anything more than that, I don't care what's reasonable or not. I care what a judge is going to find reasonable. And I think anything more than that, a judge is probably going to strike down.
yeah,
Now, keep in mind, someone needs to actually challenge it, but we're in a pretty litigious society, so the likelihood that someone challenges pretty much anything at this point is pretty high.
yep. And so down payment requirements, same. Down payment, they associations can both 718 and 720 impose minimum down payment requirements. Again, must be explicitly authorized in the documents. And remember, I think that again, there's a reasonable factor that plays into this, right, Alan?
Yeah,
Would you
agreed.
say? Yeah. So, if you're going to require a 70% down payment just to be a tough guy, I don't know that that's going to work out for you, just to be super restrictive. So, and then move in, move out, Alan, did you want to make a,
I would treat that pretty much the same as the security deposits. The reasonable amount is probably going to be based on how much damage could really be done as part of that move in, move out. The same reasonableness requirements would apply. So I would just treat that the same as the security deposit. And candidly, from a practical standpoint, just make it part of the security deposit. Just have one rather than have to try and gather multiple security deposits and then end up having to refund one and get the other one and then pursue it if the tenant doesn't do it as a potential covenant violation. It's just rather than have that headache, personally, I'm an advocate of just have one and move on with your life. Chuck, anything else on this one?
no, let's move to the
All right,
next
let's
one.
move on.
Okay. Transfer subject to approval. A big one here. Really, when I say you, obviously everyone listening should look specifically at your documents to look at definitions, particularly oftentimes the definition of transfer. It will include arm's length deals with third parties at a market rate, but exclude certain events like transfers, an inheritance gift to a family member, things like that. It will accept those from having to obtain approval, which members, unit owners, really like and need because, as we all know, life happens every single day, and those types of things happen to families, and to have to go ask the association for approval, when you're trying to move your kid in or whatever, is probably not necessary. So, Alan, if you want to make some other comments on this slide.
No, I think you covered it.
Yeah, okay. So next one. So what can we do? Well, after you get the information, the board can approve the transaction. You can too disapprove a transaction based on good cause criteria. Now, this is where we start to get into some of the nitty gritty. Negative criminal history, negative financial history, and a violation or a violation of the governing documents on its face. Oh yeah, and the good one is that we run into quite a bit is false information included on the application. Alan, do you want to talk about this number two a little bit more?
Sure. So, I mean, the negative criminal history, yeah, I can certainly understand someone with a criminal history could be concerning to the board and the members of, wanting to move into your community. But keep in mind, you want to limit, as according to fair housing law, you need to limit which criminal history you're actually considering here. If it's a 20-year-old infraction and it's a DUI, the law doesn't really consider that dangerous. Whether it is or not is besides the point. The law says it's really not. It's too old because it's 20 years ago. I mean, this person could be, they could have been 16, they could have been 20, they could have been 30, but they're probably a different person by now. And a DUI, unless they actually committed some kind of attached crime of injuring someone, probably not something that the association needs to concern itself with. So, what you really want to look at when it comes to criminal history is how recent is it? If it's anything more than 5, maybe even 7 years old, it's probably too old to really be something you can use. Is it violent? Is it fraud? Is it something that will more than likely impact the members or the residents? Because if it's not one of those things, chances are, even though it's a crime, it's not something you can use as the basis to deny someone occupancy or purchase within your community. Now, the thing to keep in mind about how this negative criminal history works, and the reason that I mentioned the Fair Housing Act, is what's called disparate impact. So, according to fair housing case law and according to the Department of Housing and Urban Development of the country and of Florida, there is a disparate impact of laws on different racial groups. So certain races, allegedly all minorities, are historically charged and convicted of certain crimes more than white males. Okay, so you need to keep in mind that that is what a court might be looking at, even if you're smart enough to completely ignore it and say, this was a crime. I'm nervous. I'm worried about this person moving in. That nervousness might not be enough to keep the person out. Now we move on to negative financial history. Is it really going to be relevant to whether this person can afford to pay the assessments that they're obligated to pay, or if it's a tenant to pay the assessments through a rent demand if the owner doesn't pay? Our firm's perspective is that that financial history is probably relevant, but you do need to have specific criteria in place. Now, a lot of the vendors that do this type of work in looking at that criminal history and financial history, some communities that we work with, the board doesn't even look at the history. The vendor tells them whether they should accept or deny something, or a potential tenant or a potential purchaser, based on criteria that the board has set in writing, that the vendor then uses to say yes or no. Now, the danger there, I know it sounds super convenient to not have to look at these things. The danger there is that you get someone else with the same name, but with a different social security number, and who is not the same person that committed these 23 murders 5 years ago, who is now not allowed to rent in your community because they happen to share a name with someone. So just be careful of that type of situation. Disapproving a transaction. I literally this morning, while I was preparing with Chuck for this meeting, got an email that in a condo, at least, the statute that pertains to collection of assessments explicitly says that the failure to have your assessments current is a proper basis. If you're allowed to accept or decline tenants, it is a proper basis to reject a tenant. Now, the owner in that case argued that that's only the case if your individual community's rules say that not being current on assessments is the proper basis. And this goes into the violation of governing documents. Okay. The arbitrator in this particular case, that doesn't necessarily carry over, but it was a great ruling and one that I think was correct and was the opinion we gave our client. The arbitrator said, no, the statute specifically says if you have the right to approve or reject, then not having your assessments current is a proper basis to reject a potential tenant or a buyer. So keep in mind, there's still some risk there, but we did get that ruling literally this morning from our client, forwarded on. And then false information included on the application. Please make sure that your application specifically says that falsifying the information will invalidate any approval automatically, because people can lie. And if you don't have that information there, there's nothing you can do about it. They can lie about their criminal history. They can lie about their name. They can lie about who's going to be moving in with them. And it's still a violation to have those unapproved occupants move in if your governing documents say it is, but it's going to be a lot easier to say, let's evict the whole group versus let's pursue a violation. The other thing that I would suggest in line with all this stuff, consider an amendment that says you can evict someone that wasn't allowed to move in because most governing documents don't authorize that. Chuck, you want to take over the rest?
Yep. Yep. Thanks, Alan. So,
Sure.
and then number three is then exercising these rights. And remember, the declaration is a contract between the members and the association. And that's a very, very important point, again, to remember across any subject, because it will always kind of reappear in different areas. So, for instance, the association might have a ROFR, ROFR, right of first refusal. You'll hear someone say, where's the ROFR rights? And it's in section 8. And the right of first refusal section typically have various notice and exercise requirements. In other words, one party has to notify the other that they're exercising their right of first refusal at least 15 days after an event occurs. They've been notified. Probably the unit owner has to notify the association first, and then the association has a period of time within which to exercise its right of first refusal. I think what we're getting to here is, and Alan, correct me if I'm wrong, it's going to be our recommendation that in the event the association does exercise any right of first refusal, it should have a substitute purchaser in the event, right?
Yeah. And keep in mind, if you don't,
if they disapprove,
because if you don't, then generally you're just rejecting the sale, which Florida law doesn't really allow.
Right.
So yeah, totally agree, Chuck.
Yeah. Okay. So, it's actually kind of a fairly high bar to successfully hit, in my opinion. And remember, even though we represent associations, I think it's important to look at the big picture. All of these things are not going to be owner friendly or member friendly, and they could arguably make it harder to sell and purchase the units or the properties. So, I guess it does make it could. Owners and members can say, well, you're making my property less marketable, basically, is the argument that you'll come across a lot, or associations might come across a lot, just as a general comment. But otherwise, I didn't have any more comments on this slide, Alan.
No, I mean, I think the most important factor to consider with respect to the right of first refusal or the substitutions is what happens pursuant to your particular governing documents when in most instances these owners don't submit this lease or this purchase.
Good point.
Is it, is the transaction void, meaning that it's like it never happened and the prior owner is still the owner? Is it voidable, meaning the association needs to actually provide notice and say, yeah, your sale, sorry, but that's not valid. You need to figure out a better way to do this and give us notice. And then a lot of times I had this come up just a month or so ago. What happens when you find out about the sale 6 months later because you're trying to send a delinquency notice and your counsel actually looks up in the public records who the owner of this property is? So keep in mind, you might need to reach out to your attorney and not just presume that everyone is going to actually notify you because you have the right to be notified. All right, I guess we can move on to the next slide. And we already talked about some of this discrimination, but Chuck, I'll let you get into detail unless you want me to cover it.
Yeah, if you can, let me catch up on my notes here and I'll jump in when I can. Thanks.
So, I mean, under discrimination, I mentioned the Fair Housing Act. That's going to protect what we label as protected classes. I already mentioned race, but also included there are national origin, familial status, sexual orientation, marital status, and in Florida and in certain counties in particular, there are additional things that you might need to accommodate. There's also disabilities that need to be accommodated, and we have an entire class on that issue. That's when you get into the the service and support animals. You get into putting in your community pool that little seat that people that are disabled are able to sit in and be able to use the pool just like anyone else. And again, we have a complete separate class on that bullet point alone. So I would check that out. And any of the classes that I mention or Chuck mentions or Jeff mentions keep in mind any past recordings we might have, which is every time we've done it for probably the last, at least since I've been back with the firm for 3 years, is on that website at kbrlegal.com. This is under the resources tab, and that's where you'll find this class recorded in the next week or so as well. But back to the protected classes, we mentioned race. National origin, you can't say, we don't want anyone from a certain country to live here. Now, there are, I think, 3 or 4 countries where real estate sales are restricted. I think it's Chinese nationals, Brazilian nationals, and I can't remember the other one offhand, but there are certain laws that you can follow, but these are all definitely consult with counsel and don't rely on anything we said today because there are risks involved anytime you're denying a potential purchaser or tenant based on any of these factors. Familial status, if you're not a 55 and over, you can't say no kids can live here. If you are a 55 and over, you still have limitations. And, keep in mind your rules, your restrictions need to be based on most of the time, if not all the time, based on behavior, not any of these particular categories. So, getting into your pool situation that I mentioned earlier, you would say that anyone who can't swim and has to wear a diaper isn't allowed in the pool. Not no babies or elderly are allowed in the pool. Um, and again, you can't say homosexuals can't rent here. That's a pretty big no-no. I hope everyone knows that by now. I actually had to amend out a provision that said no Jews or Negroes may reside in our community. That was a community that was built in the 40s, I think, and I was very proud to be part of removing that as a Jewish man myself. But anyway, the notification requirements we already kind of went through, and then Fair Credit Reporting Act. You're not going to disclose any of the information that you get in connection with the sale, lease, or transfer of these lots or units. The statute that talks about records inspections makes all of this information an exemption to what you need to produce because it contains confidential personal information. It's where does this person that doesn't live in your community live now? What's their social security number, their birth date? All information that you really could be using to steal their identity, that stays with the association. So that's only going to be shared with the board, the vendor you're using, if any, to run the conflict checks, so to speak, or the background checks, and if you need to, your attorney and your management firm. Chuck, you got anything else to add on this slide?
Yeah, one little one. I had a couple of notes about, and I think you just hit on it with the vendor. There are, speaking of notification requirements, with pulling a consumer report, there's all sorts of credit requirements. So I think, Alan, our advice will always be preferably to pay a vendor to pull any credit, et cetera, rather than the board directly or the manager directly pulling this stuff because there's just, I think, too much liability and requirements or missing those requirements.
Well, and Chuck, I'll add not only liability, but reliability. If
Yeah.
you're running your own search, unless you happen to be a law enforcement officer that's got a great database accessible immediately, and I think that would probably also be an abuse of the rights that you have as a law enforcement officer. I may be mistaken there, but you want your data to be reliable. Rely on someone else. And when it comes to the liability, if you've got someone else to point the finger at when something goes wrong, that's always going to be preferable for the association.
I'm going to interject real quick, folks. Todd and a few others in the Q&A. I'm not answering any questions that require me to be an attorney. Okay, I'm only answering questions that I can handle. Alan and Chuck are going to address some of the questions that are in the Q&A a little bit later. The reason you don't see them is because you can only see the answered questions, and the only answered questions are ones that I have answered that, again, do not require an attorney to answer. Also, in the chat area, the chat is reserved for technical questions about your issues you might be having with Zoom, maybe the volume is bad, things of that sort. Any questions for Alan and Chuck need to be into the Q&A and not the chat area. The chat area is where we will place the link for the evaluation a little bit later. Back to you guys.
Thanks, Jeff. All right. I think we were done with that slide, Alan.
Okay.
Did we?
Did you get lost?
Yeah, that's why I was trying to catch up. I'm sorry. So,
It's okay.
yeah. All right. So guest occupancy now. We've got defining terms of guests, deemed tenants. Um,
Yeah, that's basically when someone stays for so long that, you might have a 30-day period in your governing documents that, listen, if this person is staying, I don't care if they're paying rent or not, they're being
right,
treated as a tenant. They need to go through this screening process if they're going to spend this much time in our community. And a lot of times that might apply to unpaid tenants. It might apply to make sure that someone who is paying is treated as a tenant and goes through this process. Or frankly, you got a lot of the boyfriend, girlfriend, whatever, this significant other is spending 6 months out of the year in our community. We deserve to know who they are.
yeah. So the bylaws or rules could limit the number of guests, right, Alan? Like
Right.
2 to 4 per unit, or duration, as he just said, keeping that the boyfriend who's become an extended member of the family out, under 30 days a year without board approval, for instance. And again, must align with the declaration. Um, the let's see. Oh, non-relate disclosure on initial applications that I don't know what that's I don't know what that bullet
Well,
point
that's
specifically
talking,
refers to.
Chuck,
Sorry.
about disclosing who's actually going to reside in the unit
Oh,
or
I see.
apartment when you actually fill out the
Right.
application, meaning you apply for one tenant and then all of a sudden, I actually had this happen. They applied for one tenant and there's 10 people living in a two-bedroom condo.
Right.
That is not usually allowed, but check on your particular governing documents to verify.
Right. And then we have non-related guests, which is the same thing as what we discussed earlier with respect to transfers and the exemptions of transfers, immediate family members, for instance. I think we've already discussed the occupancy limitations, number of permitted occupants by non occupancies by non-owners, the duration of permitted occupancies, registration requirements. Always the governing documents must permit them, I'm sure, but a good policy is to require all guests to register so that the association, the board has their contact information.
Yeah, I mean, especially the long-term guests or the ones that are going to be repeat guests. And especially if you've got like a guard gate that you can register those people with, that makes it a lot easier because you just write down who came in. If you don't have that, that amenity available to have a dedicated individual who's registering these people, it may just mean, unfortunately, that management or the board need to pay attention to who's coming and going within the community. And as much as I hate to label anyone as a Karen, you kind of have to be at some point to be able to properly address some of these issues. And then when we talk about non-overnight guests and use of the facilities, we're really talking about, well, do the tenants have the authority to use these facilities? Do the owners have the authority to use your tennis courts, your pool, your gym, etc.? Or do people that are just there for the day have the authority to even go into these areas that are just visiting? And then we also get into completely separate from this class, but our covenant enforcement class also might get into what about the person that is hiring their trainer to come in and they're using the association gym to train them and paying the trainer? Is that person even authorized to be in the gym? And there's case law on that issue as well. So anyway, Chuck, anything else on this one?
Yeah, just one more.
Sure.
Again, the rules can limit this is applicable to chapter 720, the HOAs too. The rules can set occupancy limits, e.g., for instance, based on the number of bedrooms of the house.
Yeah.
Also require registration. I guess a lot of overlap between the two here. And I think that as we get into the next slide, the good introduction for that is that the Florida Homeowners Association Act chapter 720 section 720.305 requires compliance from the members and guests. And this is going to get into part of or one of the association's enforcement options is suspending guests and unit owners and their invitees' right to use the common facilities, et cetera, when there are violations. Or maybe are we not quite there yet? That might be the one after this. Yeah, that's the slide. That's the next slide. Sorry.
That's okay. You'll get to it.
So you want to handle this one? I
Sure.
don't have any specific
So
notes on this one.
practical considerations just for the board to kind of walk through, do you have access control? Like I mentioned a minute ago, do you have a gate? Do you have a way that you're actually registering individuals who come in and go out of the community? Do you have cameras that are tracking the license plate numbers and things like that, or some other vehicle registration? We do have a class that we just started on cameras that I don't think we've done yet. And I'm sure Jeff will tell me whether we have that scheduled in the near future, but it's another issue. Do you use the audio? Short answer is no, because that's recording someone without notice and without authorization.
October 28th.
There you go. October 28th, we'll be doing that class about cameras in particular in community associations. And that's not limited to your gate, that's throughout the community. But are you using key cards, key fobs? Can you shut those off, as Chuck mentioned a minute ago, when people don't comply with the rules and regulations,
Right.
or when they don't pay their assessments on time? Same thing with gate access. What are your front door procedures? Are you monitoring who's going in and out of properties? Do you have the authority to do that? Even if you have the authority, is it a good idea? We talked about use of facilities and common elements. We talked about screening these additional occupants if we find out that they've been there, or whatever the criteria is in your governing documents. Are you now going to create a violation if someone's been there for that 30 days and hasn't registered? Are you going to send a demand that they actually go ahead and register with the community, even if they're out now? My answer is yeah, we should. Are you going to require a new application process for lease renewals? My suggestion is it's an administrative hassle, but frankly, if someone's been a problem throughout that term of the lease, don't give them the opportunity to just stay there and cause more problems. Have the opportunity for the association to say, we don't want this person staying here. And at the end of this lease, they need to be out because we're not renewing their lease. And then member resident surveys, asking the members who actually lives in your unit, who lives in your lot. So these are just some considerations, nothing crazy that you absolutely must know, but kind of some practical tips to step and walk through. Chuck?
Yep. Enforcement. Yep. Thank you, Ellen. And so, and this then, sorry, I was a slide off. I thought I was getting us in a smooth transition into enforcement, but
It was a good
didn't.
effort.
I apologize. And it kind of was a little bit good because I think some of you might have started to ask in the slide before, well, can I just prevent the owners or tenants from even getting back to their unit or house? I can lock them out of the community, right, until they pay. No, you cannot. You cannot restrict the right of ingress and egress to and from their parcel, lot, unit, whatever. You can, however, restrict use of common facilities and amenities. So, and we'll get into that. But
let me clarify one point there, Chuck, because one thing that people get wrong is you can shut off their key fob to get through the gate. That's not blocking ingress and egress as long as there's any other way to get in. So if that means that they have to show their ID at the gate or have to punch in a code instead of just driving
we did
through,
that for a client recently. You and I did.
judges used to get that wrong. About 10 years ago was the last time I saw a judge actually rule against an association on that issue. Judges now understand you're only blocking one method of getting in and out of that community. So sorry, Chuck, just wanted to clarify that point before you move on.
Yeah. And no, why don't you handle the first point because you've
Okay.
got more experience there.
Yeah, I mean, again, we do have an entire class on arbitration, litigation, and other covenant enforcement, but that is one of the options. If someone is refusing to comply with your restrictions, whether it's not registering other occupants or they're just not registering, they sold the property or leased it without authorization. If you're in a condo, technically you can go through arbitration. My recommendation is in a condo or an HOA or a co-op, just send a demand for pre-suit mediation, which is the statutorily required next step before filing a lawsuit regarding issues like this. because arbitration just kind of gets a decision that usually is not final and requires you to go back to court to get that decision. Personally, in my opinion, and we get into this in a little more detail in the enforcement class, but mediation is a much better option to try and get this resolved. And then
Yeah.
you follow that with litigation if necessary to try and get an injunction to force these people to either remove the occupants or have the court remove them directly. And then when we get into eviction, we're talking about actually having a court order a sheriff to go in and remove these people. Now, we would do that if the declaration says we're allowed to. If it doesn't, and the lease itself doesn't say that the association is allowed to step in, which it almost inevitably won't say, then you really don't have this right. So, this is one that has to be in the declaration to be enforceable. And then, as Chuck mentioned, we've got the suspensions of use rights, denying access to the property or use of common elements with the limitations that Chuck mentioned. And then, when it comes to recovering the costs, damages, and attorney's fees, that really is going to be declaration specific. But one of the things I suggest that every board consider, if this language isn't already in your declaration, is an amendment that says that any fees and costs the association incurs in enforcing the governing documents against an owner is an assessment against that lot or unit. What that means is once you end up getting compliance, you go back to the owner instead of having to go back to court and get a specific award of prevailing party attorney's fees and costs and spend more money that you can't recover. You just go back to the owner, levy an assessment against their lot or unit, and the person that caused those charges has to pay them or gets foreclosed. So that's all I've got on this slide. Chuck, you got anything
Yeah.
to add?
No, I do
Okay.
not. Thank you.
So I'll let you handle the conclusion.
In conclusion, and some bullet point reminders, first confirm, read the governing documents. I know they're big and onerous
And boring, and that's why you have your attorney do it.
that's right. And we can help. I was going to say we can help you with that. So, to confirm, or if, as necessary, as Alan has said a few times, create the authority. If amendments are needed, we can amend those documents. To, again, establish the procedures and the proper documentation for any and all rights that we've discussed throughout this class. It's very, very important not only to have those procedures in place before the board goes and exercises them, I guess, so to speak. It's very important to document and also follow the notices in the documentation. E.g., owner requires it's a 30-day prior written notice. Those procedural aspects must be hit. Act uniformly and consistently. I think that goes without any further explanation.
I'll add timely to that. When you wait 6 months and that lease is almost up, your attorney should be telling you, listen, you waited too long. Unless you don't have the right to address renewals, what are you going to do? Send a bunch of demands and then 6 months later the lease terms over anyway? Now, if it's that no one applied at all, that's a different story. But just as a practical point, we're not out to bill every penny we can. We're out to build relationships with our clientele. So, I mean, that's the type of thing. If you're 6 months in and there's a new lease submission at renewal, I'm going to tell you leave it alone for the 6 months unless the tenant's causing a problem. Chuck, sorry, I just wanted to jump
No,
on.
no, that was perfect. Yeah, and number four, Alan already mentioned this earlier. Draft and approve, pass a resolution delegating the authority to the screening committee or board member versus a board. What's the board member versus a board meeting?
In other words, rather than have to
Right.
have a board meeting every
Right.
single time someone submits one of these packages for consideration by the association, if you delegate someone that's got their
Right.
rules set out before them, it's kind of like an architectural review where you really shouldn't need a meeting, even though you do. But if you actually, for this, rather than having to have a group of 3 to 5 people making the decision, it
Every
can be
time.
delegated to one person or a screening committee that's not comprised of the directors. So it's just an easier way of getting these things taken care of.
and that great add and save. Thank you, because I wasn't sure exactly what they were getting at. And number five is a good recap of kind of the recap. Understand what your documents say. And if you want, if you can ask your counsel to give you a short summary of the documentary authority you have or the board has, if at all.
Yeah.
So you can understand that. And again, that kind of goes back up to number one. If you don't have it, you may want to think about adding it, right, Alan?
Yeah, I mean, we work on amendments. I would say we've got 3 to 5 in my office alone going at all times that we're actively working on, not just the ones that we've sent out and we're waiting for a vote. That's a common thing to do in a community association, presuming that you've got the ability to get the vote. And if you don't think you've got the ability to get the vote, maybe try and get it once just to amend that amendment provision to make it easier to do those amendments in the future. And shockingly enough, that's another class that we've got that you're welcome to go check out on our website. Chuck and I did one, I think, just a month or two ago. So that'll be recorded and available to you. Just a governing document updates website. I'm sorry, webinar.
I think that wraps us up, right, Jeff?
It sure does.
Yeah,
Yeah.
I think that's
Excellent
it.
job.
Jeff, you
I want to interject something from a manager standpoint. A lot of the times there are things that no matter what you do as a manager, as a board member, as a committee member, you will never, ever, ever, ever be able to do something that satisfies 100% of the people 100% of the time. So what is best to do is when you have to convey news that you to somebody who you know is not going to be pleased by it, whether it's something in your documents, the R&Rs, whatever it might be, explain, take the time to explain why something is the way it is, because you tend to take a lot of the steam out of what the potential arguments could be if you just spend a little extra time to explain why something is the way it is. And also take the time to acknowledge that you are aware that not everything is going to satisfy everybody 100% of the time. There's nothing we can do that's going to do that. I don't care what it is. So folks, before we get back to Alan and Chuck, they're going to address some of the questions in the Q&A. I want to mention that in the chat area, not to be confused with the Q&A module, but in the chat area, we place the link for the evaluation. Please click on that link. Then the evaluation will open up in another tab on your browser. Fill that sucker out, submit it, and then the screen after that will have a couple of contact points to contact Alan or Chuck, as well as the firm website, the calendar for upcoming events, many of the courses of which Alan and Chuck touched upon previously during the presentation. And also a link is there to download and save today's slides. I'll go over that in a couple of minutes after our attorneys address several of the questions in the Q&A. Thank you, Kathy. It's communication. Communication. I don't care what your rules and regulations are. If you explain things, it's
Right.
typically an easier road for all of you. All right, guys, back to you.
And I will say, even as an attorney who's responding to an opposing party, I will almost never say sucks for you. It is what it is.
Right.
And I mean that.
He just says that to me.
Well, I say that to you all the time, but that's but I would never, and obviously in more, kind legal terms, I
Right.
would never really say it is what it is. This is what you got to do. I will almost always try and explain, and I won't charge a client another half hour to do it, but maybe another one sentence. This is why the rule is there, and
Right.
you're violating it, which causes this problem. Our initial letter might not do that, but if someone cares enough to come back and respond, my next response is usually going to be, listen, this is why this exists. We need you to comply because of this. For the guest restrictions, it's these rules exist to keep your community safe so that we know who is there. We have at least a little bit of information about the people that live and, operate in your community. And it's not just a free for all like living in a city that isn't governed by an HOA or a condo. And honestly, a lot of the time, it also takes me explaining why it's good to live in an HOA, a condo, or a co-op. It's not just well, you live here because we get to control you. We live here because you wanted to live in a place where the property values are maintained, everything is kept safe, etc. So anyway, moving into some of the Q&A, um, I'll start, and Chuck, if you want to jump in on any of the answers before I get to them, feel free.
Will do.
David asks, what's your take on declining a rental application based on not having a social security number? That could be a national origin issue that, someone could say, well, we are being discriminated against because we don't have a social security number. My perspective is I am fairly certain you get one of those as soon as you come to the country legally. And so if you're here illegally, I don't really have a problem. I don't think it's discrimination to say, sorry, but you can't really be here. Now, there's also the issue of, again, there are countries where US law specifies and Florida law specifies that we can discriminate. Whether that's a good idea or not, it's not for me to say. But you'll want to run those types of questions by your attorney. Chuck, anything to add there?
No, you covered that one.
Okay. Karen asks, we asked for a social security number on our sales application to run a background check. Should we destroy and black out the social after we get the background check back? And my suggestion there is no, you shouldn't need to do that because, like I mentioned earlier, and this was typed in before I mentioned it. So, Karen, I totally understand. Also, no offense by having labeled anyone as a Karen, but the answer to that is, should you destroy it or block it out? You shouldn't have to do that because that's not information that's subject to inspection by any of your members. So the reality is, if you are forced to do that, that means you're expecting for someone to screw that up. So my perspective, no need to do that. Ray asks, I might be ahead of the discussion. You might not be because we're already done. In the case of a life estate deed, when a condo has governing documentation to do background checks and an owner passes, must the beneficiary go through the background check and potentially be rejected by the board? My perspective is I would suggest doing that when the life estate deed comes to you for potential purchase. You'll also want to look at what your transfers restrictions say. If your governing documents say that that is considered a transfer, a life estate to a remainderman, which is the legal term for that person taking over ownership, then that would be the timing that you would want to use. So this is one, unfortunately, you probably want to reach out to your counsel about what your governing documents actually require in this particular instance.
Real quick, before the next question, folks, in the chat area, if you haven't already done so, press the chat button so it appears. I'll place the evaluation link in there again. After you fill that out, your required part is over. The Q&A is bonus. You're welcome to hang out, but you don't have to after the evaluation. Back to you guys.
All right. Nora asks, is a background ground of refusal if felon? I presume this means, is a felony background a basis to refuse a tenant or a purchaser? My opinion is it just depends. We talked about some of the criteria probably after this was typed in, but if it's not recent, it's not violent, and it's not financial, I don't know what relevance it would have to your community. Drug backgrounds are also going to be relevant. So there's just a limitation on what's actually going to be relevant to living in your community. If it's not relevant, my perspective is it's not something you should be considering. Ray asked, does the $150 fee maximum include the cost paid by the applicant directly to the background screening check company? Yeah, it's going to be a 150 cap according to a lot of judges. Some will allow that, some won't. So you're taking a risk. I would get that information from your own attorney. Ray also asked, can a condo charge a security deposit to a renter when the unit owner is the landlord and not the association? My opinion is yes. This is for damage to common elements, common areas. So that is a completely different security deposit from the one that's probably listed in the lease.
That's the one we discussed during the class.
Right.
That's right.
Nora asks, who trumps if you have an owner went behind the back of the association, gave a renter a lease, took money, and let the renters for 5 months and wasn't able per documents, they weren't allowed to rent for 36 months. That's a violation that you should pursue. Who trumps? The association documents come way before the lease and they will trump the lease. The only problem is you might not have the ability to evict. So from a covenant enforcement perspective, you might actually have to get an injunction that forces the owners to evict the tenant. So it's an involved process, but it's the shorter answer is yeah, you can enforce that still. Um, let's see. Todd asks, a pregnant couple soon to add a little third wants to move into a one bedroom, which will cause an occupancy violation. What's the legal procedure or allowance? There really is none. Until that child is born, there are still only two. Once it becomes three, it's a violation that you pursue. If they come back to you asking for, some kind of accommodation, that's one that you'll probably want to run by your attorney. But until that child is born, there's no violation. Not to get into anything political, but that child is not in existence for purposes of your governing documents in particular, regardless of what your political or religious beliefs may be. Our docs use the legal restrictions of 2 in a 1 and 4 in a 1 bedroom. That's part of the previous question. Same answer. Students on F1 visas with no tax ID or social security numbers who obviously have no credit or criminal history to search. How do we screen them? That's a great question for your attorney. Todd asks, can the board require social security deposit along with the owner or landlord's tenant security deposit? The answer is yes. We answered that one in respect to someone else's question. We have a major parking problem. Can we sell by auction to the owners a few parking spaces? That's one you'll need to run by your attorney because it really depends on how the parking spaces are broken down, whether they are actually limited common elements that are connected to individual units, or if they're just parking spaces that, first come, first served. So that's going to have to be run by your attorney. Ray, when a person fails the background check, can the board prevent a sale, or is it just rejecting residency? As we mentioned earlier, that's going to depend on whether your governing documents actually allow you to reject the tenancy and whether you are going to, present an alternative and a couple other factors. But the bottom line is it's not just they failed. It's that you generally, presuming that you've got the right in your governing documents and not just your rules and regulations, you can reject that tenant. All right, Todd, I don't see any other questions. Well, Todd, thanks for all your questions. Grandfather had his grandson, and just because you're a KBR client doesn't mean I can answer this over this webinar. I need to have your governing documents. And so if I don't answer directly, I would recommend reaching out to whichever attorney within our firm you're working with. But thank you for working with us. I think it's a great move. Grandfather had his grandson living there without him. He went through background checks, owner died, transferred the unit to the grandson and granddaughter. Their mother, the grandfather's daughter, claims the daughter doesn't have to go through the background check. What's the story? Again, unfortunately, that's a governing document specific identification of what your rights and responsibilities and regulations actually are. So, Todd, I'm sorry, but I don't have your governing documents in front of me. I can't answer those questions right now. Philip asks, how long does the association keep the personal identifiable information, whether denied or accepted? Presuming you even got that information, it's usually going to be 7 years, and then you should, because Florida law requires it for condos and HOAs. As of a little more than a year ago, July 1st of last year, you should have a records retention policy that says how and when you'll actually destroy those items. And it's based on the timeline in the statute. That might actually be 1 year now that I'm thinking about it a little more closely. So I would just check the statute governing records, inspections, and official records. Mark is a little confused on the definition and application of right of first refusal. Chuck, I have not shut up for about 10 minutes. I'm going to let you take this one because you covered it earlier.
Yep. Hey, Mark. So the right of first refusal, if it's in the governing documents, will allow the association to either lease the first right before any other person, either to lease that unit or to purchase that unit from the prospective unit owner who is selling or attempting to lease it. So that unit owner has a requirement. All the unit owners have a requirement. If your association has a ROFR provision that says all unit owners before they lease to anyone else must send a notice to the association to allow them to lease or buy the unit first. I hope that helps. Right of first refusal. And then the association can pass on that, say, no, we're not interested. You can go, once the association does that, which is probably the majority, they'll send a letter back. They should send communication back saying, we are not exercising our right of first refusal. Proceed with your sale. That's something that a title agent probably will want to see, for instance, to get clear title. Okay, because remember, these declarations are recorded, so it's going to come up in your title commitment for the buyer, and they're going to say, we need to make sure that the association isn't exercising its ROFR first. And that's why also, this is another thing we didn't bring up. The existence of a right of first refusal is required to be disclosed in estoppel letters, both 718 and 720. Buyers need to know this information.
Just to clarify, an estoppel letter is what goes out when someone is either selling or is mortgaging their property.
Sorry.
Basically, it's an outline of all the assessments that are due, all the violations, everything that needs to happen in order for that buyer to come in at ground zero and not owe the association anything.
I'm going to be the bad guy. 2 more to go.
Okay. Ron asks, our bylaws allow guests when the owner's not present, limited time for non-family, unlimited for family. What can we ask the owner or their guests concerning who they are and their status? You can ask exactly those questions. Are you a family member? What is your connection to this person? You can also ask the owners those questions, which is generally what community associations do. Who the hell is this person that's suddenly occupying your unit when you never told us there was a lease? You never told us anything was going to change. Who's this person living in our community that is impacting our community? Holly asks, does the duration need to be spelled out in the declaration? If we're talking about the duration of the occupancy before someone is considered a tenant automatically, yeah, that needs to be spelled out in the declaration, or the declaration needs to say the board gets to decide what the time frame will be, and then there needs to be a board resolution that actually makes that decision, or a rule, regulation, whatever you want to call it, that does that instead.
All right. Excellent job, gentlemen. I know you have appointments waiting for you as well. So before you head out, I just want to give you the opportunity one more time, the way you would prefer people reach out to you both. You prefer email, phone call, both?
Either.
All
Whatever's
right.
easiest for you. We're here. We're happy
Sounds
to help.
great.
And for me, because I'm in and out of the office frequently, but I do have email on my phone, that doesn't mean I'll automatically respond to you at 11 o'clock at night, but it does mean that I'm more accessible via email. So the email address that's on the slides, that's on the screen right now, right underneath my name on the top right of my little window, that's the easiest way to reach me, as@kbrlegal.com. Thank God Jeff Rembam agreed that it's not going to be a Schwartzseid this time. And then also LinkedIn. I do tend to post usually every 2 to 3 days during the week to try and share something that's hopefully valuable to people that are in the community association industry, or in legal, or in mediation.
All right. Well, thank you both.
Thanks,
And
everybody. Appreciate
Thank
y'all
you,
attending.
everyone.
It was a good class, good attendance. We appreciate it. And as Jeff mentioned, it's not just reaching out regarding these issues. Feel welcome to reach out if your community needs literally anything.
absolutely. All right, guys. Go kick some butt. Talk with you soon.
Thanks,
Jeff.
gentlemen.